All right. Hello and welcome. Hello and welcome to another episode of Deportation Defense Live. Thank you all so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And today we're talking about asylum law, and we're talking about the one-year bar, the one-year filing deadline, which is required on asylum cases. And so welcome and thank you for being here. Remember that the Deportation Defense Live is here to train, teach, inspire, and empower immigrants who are facing deportation to make the most out of immigration laws, to make the most out of their lives, and to win their cases. Are you facing removal in immigration court, or do you know someone who's facing removal in immigration court? Because if so, you know that it is not easy. All right, it is an uphill battle. The laws are against us. And here at the Deportation Defense Live, we're here to maximize your chances of winning that case. All right, so today our theme is asylum law and the one-year filing deadline. And I'm going to jump right into it. And if you have questions as I'm talking, feel free to ask your questions. I'll do my best to answer them right here, right now, live. All right? So the basics, which you'll remember, the basics is that to win asylum, you have to show that you have a quote-unquote well-founded fear of persecution on account of your race, your religion, your nationality, your political opinion, or on account of your membership in a particular social group. You have to show, oops, got an incoming call there, sorry about that. You have to show that you have not triggered any of the bars to asylum, which is what we're going to focus on today, and you have to show that you warrant a favorable exercise of discretion. Okay? So those are the basic requirements for asylum. Now there are several bars to asylum. There's the firm resettlement bar, the material support bar, persecutor of others bar, particularly serious crime bar, the previously applied bar. There's other bars as well, but the one I want to focus on today, which is by far the most, just the most common that we come across and that we have to argue, it causes the most grief of all the bars, is what we call the one-year bar, which is the filing deadline for asylum cases. All right? Basically, the one-year bar says that a person must file their application for asylum within 1 year of their most recent entry. Otherwise, that asylum case is untimely. It'll be denied. Okay? And not knowing about the bar, not knowing about the law is not an excuse. In fact, in the regulations, there's only two ways around the one-year bar, and I want to talk about those, but first, we've got to just be aware, right, that somebody's arriving, whether they're arriving on a visa or arriving through the border, they're afraid for their life, they're fleeing from death, violence, persecution in their home country, and now within 1 year, they've got to talk to a lawyer, they've got to figure out whether or not they qualify for asylum, they've got to hire that lawyer, they've got to build their case, and they've got to file it. Okay? And so that's what the law requires. That I disagree with the one-year bar. I wish it didn't exist, but it does exist. All right. Fun fact: it doesn't exist in many other countries in the world, but it does exist under U.S. law, and so we got to know that. All right. But there are two ways around it, and you want to talk those things through. If you have missed the one-year deadline, then talk it through with your lawyer, because see if one of the exceptions might exist, and talk it through with your lawyer as soon as possible. And if you're coming up on the deadline, then don't wait, don't hesitate. Talk to a lawyer quickly, okay? So there are two exceptions to the one-year rule, all right, to the quote-unquote one-year bar. Those exceptions are, number one, exceptional circumstances, and number two, changes in circumstances. So I'm going to talk about exceptional circumstances first, all right? The regulations allow a person to get around the 1-year filing deadline if they, 1, can demonstrate extraordinary circumstances, 2, if they can show that those circumstances directly related to the failure to file within the 1 year, and 3, if they demonstrate that their delay in filing was quote-unquote reasonable under the circumstances. And by that, they mean, okay, after that exceptional circumstance ended, that you filed it within a reasonable amount of time. Okay? And the regulations list 6 different types of situations that can lead to quote-unquote extraordinary circumstances. So I want to go through them so that, so that we're clear. The first is if there's quote-unquote serious illness, all right, or mental or physical disability. And so, and those can include the effects of persecution suffered in the past. So sometimes one of the strategies is to get a thorough psychological evaluation or emotional evaluation to see maybe there's PTSD involved, maybe there's other things that could have contributed to the delay. All right? So serious illness or mental or physical disability is one of them. The second listed situation that is a quote-unquote extraordinary circumstance is for what we call legal disability. And so that's, for example, if someone's a child, right? If someone suffers from a legal mental impairment of some kind, then they can have arguments around the 1-year deadline. Number 3 is if there's ineffective assistance of counsel, which is a term, right? If there's actually been a showing that a previous attorney committed malpractice, right? Like really gave you incorrect legal advice, or failed to help you, or you paid them to help you file for asylum and they took your money and ran away or something like that, which those things do happen, unfortunately. Those can give rise to an extraordinary circumstance to allow you to file asylum a little bit late. But you still have to move within a reasonable time period after discovering what those attorneys did. Number 4 is if you've maintained status. So if you've maintained a visa or TPS or parole or something like that, and you've been maintaining it, then once that status expires, now you are given a reasonable time to file your asylum application, typically up to 6 months, right, after the expiration of some kind of some other immigration status expires, you can file for asylum. Okay? Number 5 is if the applicant filed an asylum application before the extension, but then that application was rejected for some reason. All right? We can show that the rejection, was that, yes, it was rejected, but you intended to file by the 1-year filing deadline. And so that's good that that's in there. All right? You still have to refile and fix the whatever reason for the rejection. You still have to fix that and then get that back on file within a reasonable time period. But still, at least you can demonstrate that you attempted to get it on file before the deadline. And lastly, it says if there's a death or a serious illness or incapacity of the attorney or the legal representative, or sometimes of a member of the immediate family of the applicant. And those are the 6 listed exceptional circumstances. Okay? And it's a non-exclusive list, which means if you had your own issue, then you could make the argument, but that's that. Okay? So those are exceptional circumstances, which is one of the main things that need to be argued to get around the 1-year filing deadline. And so now I want to talk about the other one, which is change in circumstances. So the existence of changed circumstances which materially affect the applicant's eligibility for asylum is the other way to get around the 1-year filing deadline. All right? You still have to file for asylum within a reasonable time period after the change in circumstances. And so what we're talking about here is typically two things. One, it's a change in your country, all right? And so if there's like a war or a coup or a, some kind of a change in political regime that now the government of your country, now your country is no longer safe for you, if that happens, contact a lawyer right away. And maybe you weren't eligible for asylum before, but maybe because of that change that happened in your country, maybe now you have an asylum case. Okay? So that's, and it could be a change in the president of a country, it could be a change in the, there's several things that could be considered there. Some kind of change in your home country. The second type of change is if there's a change in your own personal circumstances that materially affect your eligibility for asylum. So where I've seen this, for example, is where a person is in the United States and, we've seen this in a couple places. A person is in the United States, maybe studying, maybe working, doing their thing, and maybe growing up, if they entered as a young person, and now they have realized that they are, maybe they've realized that they are gay, all right? And so they come out and discover their own sexual orientation. Well, that self-discovery, so to speak, can, in some instances, be a material change in their circumstances that might affect their arguments for asylum. Maybe their home country does not welcome that change in their circumstances. Okay? Similarly, we've seen this and made this argument where a client is here in the United States and then converts to a new religion. And if they convert to a new religion that is disfavored in their home country, now maybe they would have arguments for asylum. There's other things that might happen and that might lead to this type of change of circumstance. The point is that if you go through a change like that where now you're afraid to go back to your country, talk it through with a lawyer, all right? And a good lawyer in a consultation will ask about any changes that have happened recently. And then if those things have happened, you'll want to file your case within typically no more than 6 months after that change. Got it? So we're here. Thank you, everybody, for tuning in. If you're just now tuning in, my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I'm talking today about asylum, and specifically about the 1-year filing deadline for asylum. And yes, if you've entered the U.S., you have 1 year to file for asylum, and there are these two narrow exceptions that I just went through for extraordinary circumstances or for changed circumstances. So that's what we're talking about, okay? And if you have questions about this or about anything, please send them over, all right? And while you're doing that, I'm going to tell you a little story. So I had a client years ago who was fleeing from her country and who had suffered persecution in her country based on her religious beliefs, all right? And she had entered the U.S. on a visa, but she did not know anything about asylum law, and she applied late. She applied past the 1-year filing deadline, okay? And so the asylum office, because she missed the 1-year bar, the asylum office referred her case to immigration court, and they initiated deportation proceedings against her. And then, in front of the judge, we had to argue and explain that she had overstayed her visa, all right? She had been sick. She couldn't travel. She had tried to find lawyers. She wasn't able to. And she had filed as soon as she was able to. And the judge disagreed with our arguments. And the judge found that her delay was too much. And so the judge denied her application for asylum, but the judge approved her application for withholding of removal. And that sometimes happens. All right? Withholding of removal is worse than asylum. She won't ever be able to get a green card. She won't ever be able to bring her parents into the U.S. But withholding of removal does not have a 1-year bar. Asylum law does. Okay? And so that's kind of just an example of, in practice, how it works. Okay? And so, so the bottom line there is, just because we have a few arguments to try to get around the 1-year bar, it does not mean that the judge will agree. And that's why it's always best to file within 1 year. But even if you blow the 1-year filing deadline, sometimes it's still worth fighting. Sometimes you can still win asylum. Sometimes you might be eligible for withholding of removal. You know, and if something bad happens to you while you're here, then you want to talk it over with a lawyer quickly, because you can file it within 6 months or within a reasonable time if there is a change in your circumstances, or if there's some sort of extraordinary situation that prevented you from filing on time to begin with. Okay? That's it. That's it. That's basically what I wanted to share today. I feel like I just said a lot. Hope this was useful. I hope it was helpful. I don't see that I've received any questions today, which is fine. And so, so my empowerment tip, I like to give an empowerment tip. My empowerment tip this morning is to be curious. All right? Ask more questions in your life. Ask. There's power in just asking questions. And ask your spouse questions you've never asked them before. Just out of curiosity. Ask your coworkers questions about themselves. Every human being can learn things from other people. All right? You can connect more with people, which helps you to be more authentic. And it helps others to be more their authentic selves around you. Ask your lawyer more questions. All right? And encourage your lawyer to ask you those questions too. If you can do this, now talking to lawyers, if you can do this and ask questions in a way that stimulates authentic response, if you can do that in a courtroom, you will win more cases. All right? And if you can do this in your life, you'll win more in life too. All right? There's something to be said for like really getting to the bottom. You know, part of the extraordinary circumstances and changed circumstances theme, part of the ways around the 1-year bar, it's like you really need to ask and get to know the person you're talking to. Like, why is it that you didn't file for asylum before? Why were you afraid to come forward and file that case? Like, really get to the bottom of it, because asking makes all the difference. Okay? So anyway, that's my empowerment tip for today. I hope that's useful. Hope that's helpful. Thank you all so much for joining. All right? Thank you all so much for joining. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. If you still have a question that I haven't answered, please still send it to us, and I can upload answers to those questions through to our channel in YouTube. So to see those, please subscribe to our channel in YouTube. And when you do that, click the notifications bell also, and you can receive an update when we have additional updates and news and things of that nature. I see a question come through right now. Thank you. Is this Clydesdale? Clydesdale, I think it is. I have a question about an I-589 application for asylum and withholding of removal. What's next? What's the next steps if the Department of of Homeland Security dismissed the proceedings under the Code of Federal Regulations 8 CFR 1239-2. So thank you for asking that question, all right? If you have your proceedings in immigration court dismissed, but if you previously had an application for asylum and withholding of removal pending, then there are regulations in place that allow you to refile your I-589 in front of the asylum office, all right, for a couple things. One, to get your work permit on file so that you can continue to renew your work permit, etc. But two, they are dismissing several asylum cases in front of the immigration court for the purpose of allowing people to first file and have their application reviewed by the asylum office. And so that's what that is. All right? So Clydesdale, if you need help with, or if you want a second opinion, or if you want us to review in depth your asylum application, hey, we'd love to do that. Please just give us a call. We're here to help. We'd love to help. And to everybody else listening, hey, thank you all so much for being here. My name again is Otis Landerholm, and my law firm, Landerholm Immigration, A.P.C. We're here for you. We'd love to help. We're based out of Oakland, California, but we handle cases throughout the United States, and we have clients throughout the world as well. And so if you have an immigration case, please give us a call. We are here to help. We would love to help. Thank you all so much for tuning in, and we will see you next time on our next episode of the Deportation Defense Live. Thanks so much. Have a great day. Take care.